Hello, and thank you for joining us today for this important webinar. My name is Ellen Factor, Managing Director of Membership in Dental Practice. We know that these are extraordinary, unprecedented times as we sort through the COVID-19 crisis and the impact on dental practices. We know there is a lot of information, a lot of things you need to evaluate when you make the decision on whether to temporarily close down your office and how to do so. Today we have Elizabeth Levine, employment lawyer with Goulston and Storrs, with us. She will address issues related to staffing concerns for temporary shutdown. Following her overview, she will respond to questions that were submitted prior to this call. This webinar will be taped and available on the MDS website shortly later today. If you have additional questions, please email them to membership@massdental.org and we'll respond after the webinar. Please know that the MDS is here to help, and we will do our best to keep you informed. And now I'll turn the program over to Elizabeth.
Thank you, Ellen. As an employment lawyer, it goes without saying that that these really are unprecedented times. Just before we begin, I see that we have a number of your member participants who have joined us, and I want to make sure it's clear that the firm, Goulston and Storrs, is counsel to the MDS, and so we're not providing advice, legal advice, to any individual practices by way of this webinar. What our goal is today is to provide a general overview of employment matters in what is a highly dynamic time. We're in a fluid situation where both the laws and frankly the advice that we're giving may change. So to the extent that your members have specific questions or require specific legal advice, we would just suggest to them that they seek legal counsel. In addition, my understanding is to the extent that we've got changes or other guidance that the MDS wishes to provide, it's going to continue to do so on its website. So just to begin, what I'd like to do is to give a general overview. Employers are faced with any number of scenarios in light of the current pandemic, whether it's because of mandated closures or loss of business. Employers are trying to best understand what kinds of options they may have with respect to their employees. And for employers who are able to continue operating their businesses, perhaps at with some sort of economic consequences, negative economic consequences, there are a number of different scenarios. For example, employers could be thinking about across the board pay cuts. For example, everyone in the practice will take a 10% pay cut or a 20% pay cut, but we'll all continue to work for some period of time to ride out the storm. That's certainly an approach that we have seen. You could also reduce an employee's hours, particularly with respect to hourly employees, such that, rather than having an hourly employee work 5 days a week, we're having them work 3 days a week or 4 days a week. That becomes more complicated with your exempt employees, and we'll talk a little bit about what that looks like in a couple of minutes. But certainly that's another approach to the financial consequences of the COVID-19 situation that we're in. For employers who have to take more dramatic cost-cutting measures, either because they can't stay open, they're simply not permitted to, or they otherwise need to close because they've had such a significant business interruption, we're seeing primarily two different approaches to those staffing issues. The first is what's called a furlough, and the second is a layoff. And they're different. A furlough is essentially when you tell an employee that they are not going to be working for a period of time, but they will continue their employment. So whether it's a 1 week furlough or a 2 week furlough, or maybe a month, for example, because the practice needs to close or because you need to reduce staffing. So the employee would remain employed, which means that they would continue to be benefits eligible. So they would continue to receive their health benefits, provided they continue to pay their share of the premium. Now, of course, you can work out whatever arrangements you may wish to work out with the employee. For example, if you think it's going to be prohibitive for an employee to continue to try to pay their share of the healthcare premiums, while they're on an unpaid leave. Certainly the practice or the employer could advance those premium payments on behalf of its employees, and then do a true up when you come back to work. That's certainly fine. The other questions that we often get about furloughs are, well, what happens to the vacation time, for example? Well, one of the benefits of a furlough is that the employee continues to be employed. So there is no obligation to pay out final pay, including accrued but unused vacation time, at the time that the furlough starts. That means that as an employer, you can also decide whether you want to permit or require employees to use their paid time off during the period of the furlough. Oftentimes employers implement furloughs because they have cash flow problems and they're not in a position to pay out unused vacation time. So an employer can decide, look, the furlough is going to be unpaid, we're going to hold your vacation time. If the furlough becomes permanent, i.e. it becomes a layoff, you would then pay out the vacation time at that time period. Now, you may be worried about, well, gee, how can people go without compensation for 3 or 4 weeks while I'm telling them they're still employed? That doesn't make sense. How can they get some sort of salary reimbursement or some sort of supplement? Well, the Massachusetts unemployment system specifically provides that individuals who continue their employment are in fact eligible for benefits. So if you have an employee whose hours are reduced or whose pay is cut, or who is furloughed, right, is told not to come in for some period of time, those people are eligible to apply for unemployment. Now, who can apply? Well, it's essentially any W-2 employee. So if you are a practice owner and you are paid on a W-2 basis and all of a sudden you have no work, you're entitled to apply for unemployment. If you're a partner or you're K-1, you're probably not going to be covered. So that's a little different situation that you find yourselves in. But for most employees, even if you've got a reduction in your hours, you're entitled to apply, even if you continue with your current employment. Now, how much will you be entitled to earn with that, or how much will you be eligible, to receive, depends on how much money you have earned over time. I understand that for most of our dentists, they're either paid a percentage of services rendered and the like, and that's okay, right? Because that's generally considered W-2 income, if that's how we're paid. And then we would go ahead and the Division of Unemployment would look at what your wages are over a period of time, and then would pay you based on what those wages have been. And at the moment, unless we get some relief, unemployment insurance covers 30 weeks. It covers up to 50% of your average weekly wage, up to a maximum of $823 a week. And I understand and I appreciate that that's probably not as much money as many of the participants or many employees in your practices are making, but it's certainly some relief that that we hope employees will be able to take advantage of. If you furlough an employee, there is no requirement to provide any sort of writing or written notice or otherwise to provide to the employee notice of their unemployment benefits. But my recommendation is always, look, you should send something, right? Whether it's a letter or it's a memo, so that employees understand they're going to be out of work for a period of time. Now, you can set the furlough at 2 weeks or 4 weeks initially, and then you can extend it if you need to, or you can shorten it if you wish. So furloughs have lots of flexibility around them. You're not also obligated to provide an employee with notice of their unemployment rights in the event of a furlough. But again, I also have been recommending to clients that they go ahead and do that. No one's trying to hide the ball here. I know many employers are concerned about what's going to happen to their unemployment rating if they go ahead and have lots of employees filing for claims. But again, our hope is that the state would implement some sort of relief. I know New York yesterday, actually, their unemployment compensation website crashed because they had so many employees or former employees trying to apply for benefits. So I think this is an issue that the state hopefully will take a look at and will try to address. If, however, you're not thinking furlough, if you're thinking, I need to close my practice, or I actually need to permanently terminate employees, well, that's okay. And that's an option here too, as long as we do that in a manner that is not discriminatory. I often hear from clients, gee, I don't have to terminate my entire workforce, but you know what? I do have 1 or 2 people for a headcount reduction that would allow me to preserve all of my other jobs. Well, if that's the case, we can go ahead and you can terminate an employee. Most employees are at will unless they have an employment contract. If you have an employment contract, you need to be taking a look at that contract to understand what kind of rights the employee may have and how much notice of termination you have to give them. If they're an at-will employee, there is no advance notice requirement. You would simply notify them of the termination. But that, of course, has consequences for both the practice and the employee. So at the time of termination, the practice would be required to provide on the day of termination, actually all unpaid wages through that day, as well as all accrued but unused vacation time. So there's a financial impact there. Again, you're required to notify employees of their ability to file for unemployment, and as well send out COBRA and or mini COBRA notices in connection with an employee's healthcare benefits. That also has pretty significant financial consequences for the employee, because now, of course, they're not going to be in a position to have any sort of employer contribution in connection with their healthcare, and they're actually going to be responsible for 102. It's generally 102% of the premium if they wish to proceed under COBRA, because they would be paying 100% of the premium as well as a relatively small administrative fee. They would, of course, be entitled to, as I mentioned, apply for unemployment in those circumstances as well. So I think that's our sort of general overview, Ellen. I know that you had kind of a series of questions that you were hoping to walk through. I don't know if you think now would be a good time to do that, or if you had other kind of very specific areas that you wanted me to talk about.
Yeah, well, I'd like to start with the questions that have been submitted by members.
Of course.
Some of them you may have covered, but let's walk through them, and
Sure.
you can address them again, because there seems to be some confusion. So the first one is, this group of questions is specifically around furlough.
Yep.
So the question is, should we indicate to our employees that we're likely to furlough, not lay off at this current time?
Well, it's really a business decision. You know, there's a lot of uncertainty around what's going to happen, both, you know, within kind of the specific industry, but kind of generally, right, within the world, like what is going to happen, what's going to happen to our economic stability and the like. Practices could certainly tell employees that their hope is that they're going to furlough rather than lay off. But again, you know, it's really a business decision. Now, the other issue, of course, is we don't want to be making any false representations about what's going to happen going forward, because you don't want employees to rely on that. If employees are asking, you're certainly free to tell them that that's what your hope is going to be. Your hope is going to be that you're not going to have to lay anyone off, but we really can't give any guarantees.
So the next member wants to know, you know, is it better just to put everybody on furlough, and while I'm doing that, keep track on minimal hours worked by business personnel and dental assistants, and then compensate them afterwards when we're reopened?
No, we can't do that. The wage laws make very clear that you have to compensate people for hours worked within a specific period of time following the end of the work week. So if you have hourly employees, even if they're only working minimal hours for you in the course of the work week, you have to be paying them in accordance with your regular payroll schedule. You can't wait and pay those people when the office reopens, or we'll have otherwise created a pretty sticky wage situation for ourselves. With respect to exempt employees, you are required to pay exempt employees their standard salary for any week during which they perform any work for your practice. So I would be very careful about requiring exempt employees to provide a couple of hours of service here or there, because you're going to be obligated to then pay them for the entire week.
Okay, so the next question is, how do you suggest dealing with the possibility of furloughing all clinical employees and paying their business staff if they are working on a part-time skeleton schedule? Hygienists are completely not seeing any patients, and dental assistants are staying home, and if they are asked to assist during an emergency, are they then coming into work? Can they be still considered on furlough?
Yeah, so first of all, you can furlough some staff and not others. So it's perfectly appropriate to say particular areas of our business are going to be out on an unpaid leave of absence. They're going to be furloughed for a particular period of time. It's also okay to quote unquote furlough certain employees, but have them on call in emergency situations. So the dental assistant who's asked to come into work on an emergency basis, that's okay. Now, the other question, of course, is whether we have to pay employees who are on call. Not in Massachusetts, at least not if they have the ability to sort of come and go as they please in their own personal space. So if, for example, you require employees to be in a particular location for a particular period of time because you might need them and they don't have the freedom to move about more freely, you probably would have to pay them for that. But if they're simply home or going about their day-to-day business and you give them a call and you say, I need you to come in today or tomorrow or whatever the case may be, you don't have to pay them for that on-call time. You only have to pay them for the time that they're actually working.
So there's still some confusion out there from members about what's the difference. I know you went over this in your intro, but what is the difference between when you say somebody is furloughed and then somebody is laid off?
Yeah, so if someone is furloughed, they are still an employee of your practice. If they are laid off, they are terminated. They're no longer an employee. They don't get benefits. You have to send them a COBRA notice. If they're furloughed, they're still considered an employee of your practice, although they might not be providing services for you at that very moment. And again, I really think the biggest issue here is that they're going to continue to be eligible for your health benefits, at least for some period of time in accordance with your plan documents.
Okay. And then what happens to an employee's PTO during a furlough? Do they still continue to accumulate it?
No, they generally don't. Generally speaking, employees don't accrue PTO while they're not working. It really depends on the language of your specific policy. So, sometimes employers will have a lump sum policy where you're just entitled to the time at the beginning of the year. If that's the case, your employees have already been given that time. They're entitled to it. It's going to sit in their bank during the period of furlough. You don't have to let them use it, but they still have it. Most other employees' policies will say that that you earn time based on time worked, and in those circumstances, you're not going to earn time over the course of a furlough because you're not providing any services. That's also something that I generally suggest that employers clarify when they notify employees about a furlough. Again, a simple one-page letter that describes the fact that they're going to be out, that they're not going to, they won't be accruing any paid time while they're out, and whether or not they can use existing paid time balances during the period of the leave.
So what if somebody wants to continue to pay somebody at this juncture, but then the juncture gets longer and then wants to switch somebody to furlough?
That's okay. Yeah, that's absolutely okay. You can, again, the situation is fluid. And you can have an employee who you say, look, we're going to put all of our employees out for 2 weeks and we're going to continue your pay for 2 weeks, and you're not going to be obligated to use your pay time off. And if for some reason that period gets extended, you can decide at that point, look, you know what, we're really not in a position to continue to pay people, so your furlough is going to be unpaid. And at some point, you could even decide that you really need to terminate that employee rather than continue to have them or continue to hold their job for them. So you can do that if you need to.
Okay, and I know the answer to this, but I just want you to repeat it, that in either case, a furlough or a layoff, they can choose to file for unemployment.
Yes, that's exactly right. That's exactly right. Yep. If they are either no longer employed or they've had a reduction in hours, they're entitled to file for unemployment. Yes.
Can somebody force employees to use PTO prior to putting them on furlough?
Well, I'm not sure why you would force them to use PTO prior to putting them on furlough, but you can require them to use PTO during the period of furlough. Essentially, forcing them to use PTO is essentially requiring them to take the time off either way. So I'm not sure that it makes a huge distinction, but yes, you can absolutely tell employees, look, we expect you to not come in for a period of, X day to Y day, and we are going to require you to exhaust your existing vacation time during that period. You cannot, however, require employees to use sick time. So if they're not sick, you can't require them to use their sick time.
Okay, now I'd like to shift to questions that people have submitted regarding exempt versus non-exempt employees and the reduction of hours.
Sure.
So can you please elaborate on if they're allowed to decrease the salaried employee's salary?
Yes. So you are permitted to do salary reductions for the same quality of work and the same quantity of work. So for example, if everyone in the practice, as I said, takes a 5% pay cut or a 10% pay cut, or all of your exempt employees suddenly take a 5% pay cut or a 10% pay cut. The problem you may run into with exempt employees is if you want to reduce their weekly salary for a reduction in work. So the laws are very clear with respect to exempt employees that they have to be paid the same salary for any week during which they perform any services for the practice. The law is also clear that you are not allowed to reduce an exempt employee's salary based on lack of work or quantity of work. So there have been several opinion letters that have been issued that have said in a situation similar to this, where we need to reduce an exempt employee's hours as a consequence of reduction in work, to also reduce their pay accordingly could risk their exempt status if we're doing this on a temporary basis. If the expectation is that the reduction in salary and the reduction in hours will be long-term or more permanent, that's okay. But we don't get to reduce salary and reduce hours as sort of a stopgap measure. I will say that, I do, again, have worked with companies who will reduce exempt employees' salaries and tell them, we still expect you to continue providing the same level or quality of services that you're providing than that you have been providing, just for less compensation. The other issue that you need to be thinking about if you're going to reduce your exempt employees' pay is you need to make sure that you're staying at that same, or you're hitting the minimum thresholds that are required by the Fair Labor Standards Act, which is $684 a week. So you have to make sure that if you decide to reduce an exempt employee's salary, that you continue to pay them at least that $684 in order to maintain the exemption.
Okay. Another question is, if somebody is actually collecting or taking PTO during this, how will that reduce what they're eligible for unemployment? Or does
yeah. So if you're collecting PTO and you're essentially getting paid, you're not going to be eligible for unemployment. I mean, unemployment is for individuals who are not currently receiving what their prior salary was. So if you're receiving PTO, you're probably not going to be likely to be eligible for benefits. If, for example, you are only receiving a partial PTO, so for example, you don't have enough PTO to cover the entire period of the leave, that's a little different, and you eventually would become eligible once your PTO runs out. But that's a question that the Division of Unemployment likely would be asking.
Okay. Now I'm going to shift gears over to unemployment questions.
Yeah.
Can employers apply for unemployment?
Yeah, well, so that depends on how they're paid. So if the practice owner, again, is a W-2 employee, that person is likely eligible for unemployment, depending on the circumstances leading to the loss of available work. If they're a partner, on the other hand, they're probably not eligible.
Okay. If a staff member is furloughed, is filling out an employment claim, this is kind of more specific.
Yeah.
And you're looking at that employment claim, which I know that you can do online now.
Yep.
Do you know what box they actually would check? There's a box that says still working, and there's another box that says discharged.
Yes, so the discharge is for the person who has been terminated, who has been notified that their employment has ended. The person who is on furlough would be quote unquote still working, either part-time or on call.
Okay, is there a difference? Is there a difference between unemployment for a part-time or a full-time employee?
No, the only difference is how much the individual would be able to collect. Whether you're full-time or part-time, you're still eligible, so long as you have paid in the requisite amount to the unemployment compensation tax system over a period of, I think it's a certain number of quarters. So there's a look back, right? And I think it's $5,100 to know whether a person has been eligible times a certain amount of the state average wage. So doesn't matter whether you're part-time or full-time, as long as you have paid in enough, you'll be eligible for benefits. And what your benefits will be going forward will be impacted by what your prior compensation was.
Okay, in this question, this member said, is staff is being paid for the entire week through Friday? I'm thinking they're talking about this week. Do they have to wait for the end of the pay period before they can apply to collect unemployment?
No, for example, if they are working through Friday and the expectation is that they're only going to get paid through Friday, then they can go ahead and they can apply as soon as it's been made clear to them that they're either going to be furloughed or otherwise laid off.
Okay. So is it true that employers will not be penalized for an increase in unemployment tax rates for employees collecting during the COVID-19 closures?
Yeah, we don't know. I mean, that's certainly my hope, is that will be some part of the relief that will be afforded to employers going forward. The expectation is that there's just going to be a flood of unemployment claims, and it would be unfair and unreasonable to expect employers to suddenly suffer the consequence of a much higher experience rating. But again, we have no idea what's going to happen with that. It's similar to, there's a bill that's currently pending also, again, that we really don't know what's going to happen, that is going to, on the federal level, that seeks to mandate paid time off for sick purposes, as well as paid time off for leave as a consequence of COVID-19. But again, these are just bills, and we're really not sure what's going to happen with those.
So a lot of members are struggling with, they have employees that are long-term employees that are, they think of as family, and they want to continue paying them. What suggestions do you have there?
Yeah, so here's my only concern with that, is we need to make sure that we're treating our employees similarly. So to the extent that we've decided we've got a couple of long-termers who we really want to pay during the period of leave, but not others, I worry a little bit that we could start to be accused of discrimination, that we're treating people differently. My expectation also is that the long-term employees may be the more highly compensated employees. And that's another issue that you need to be concerned about. You want to make sure that you're not treating your more highly compensated employees better than your lower compensated employees, because then we start to, again, find ourselves in wage claim world. But look, if at the end of the day we want to afford some financial benefits to our employees, because we care about them and we understand that this is pretty impactful across the board, certainly free to do that if you wish.
Okay. Now I just want to shift to some questions regarding the use of PTO that have been submitted. This dentist writes, we are having our staff use 2 weeks of PTO. Is it legal to have them use their own earned time? What happens after 2 weeks? What should we advise them?
Of course, you can absolutely require employees to use their paid time off or their vacation time. Again, it's a little bit different with sick time because sick time is really earmarked for when the employee is sick. So you can't require them to use their sick time, but if they've got a bank, for example, that's a little different. You can require them to use the bank. After the 2 weeks, if they're out of time, they're going to be on an unpaid leave unless the employer wishes to continue to pay them or to otherwise provide more time.
Okay. So this question is related to a health center. This member writes, the health center has closed the department, the dental department, but remains open. The health center is closed, but the dental department remains open. In this situation, they're expected to use all PTO that they have accrued, and then they're asked to go negative for further time.
Yeah.
Is that permissible?
Yeah, so your employer can require you to take accrued time. If the employee decides that they don't want to go negative, that's certainly their choice. An employer can't require you to go negative per se. You can simply say, I'm out of time and I don't want you to pay me anymore. That's certainly fine. And then the individual can apply for unemployment.
Okay, the next question is, I have an exempt employee who has already used up all her PTO this year. She's now on furlough. She worked part-time of the last pay period. Do I have to pay her full salary amount for that week, or can I prorate her?
Yeah, you have to pay her full salary for that week. If she had decided voluntarily that she didn't want to work for the full week and she had exhausted all of her PTO, that's an exception to the general rule during which you could pay only for the partial week. However, if the employee is on furlough or has been is otherwise required to stay home and they don't have any more PTO time, then you would in fact have to pay them for the full week. The distinction is whether it's voluntary or involuntary.
Okay. The next questions are on the issue of staff that's paid based on production. So the question is, what about the associate dentists who are paid on production/collection? Are they still eligible for unemployment even if we are still on call?
Yeah, yep, you are in fact eligible for unemployment. Again, so long as you're W-2 employees, and how much you're going to be eligible to earn will be based on your prior base wages, and whether those production/collection fees are paid as a wage rather than something else will determine, what those base wages look like. You are still eligible for unemployment even if you're on call because you're not being compensated for that on-call time. To the extent that you are called in and are paid some amount, that amount is simply going to reduce the amount of unemployment that you will be otherwise eligible to collect.
Okay, another associate question is, I am an associate getting paid on salary. The owner of the practice is retired and only handles front office issues. I am still needed to be on call for emergencies during office closures. Should I be paid my salary during this on-call emergency period? Does the owner have the right to deny me pay during this time?
Yeah, if the salaried employee is not actually providing any services, even though they may be on call, not obligated to pay them. Now again, the on-call depends on whether you have the freedom of movement or if you are otherwise really required to be, a certain number of miles from the practice such that your freedom to move around is otherwise restricted. But again, that's something that you would want to look at much more closely and much more specifically. That's going to be a fact-specific question about whether someone's freedom of movement has been sufficiently restricted such that they need to be paid while they're on call. But generally speaking, if I'm sent home on Friday and I'm told, look, I need you to be on call, if I need you, I'll call you, or I'll let you know the night before, for example, that's not someone who's going to be entitled to be paid for that week.
So thank you. That was the last question that has been submitted. I invite anybody listening to this call that has additional questions to submit them to membership@massdental.org, and we will do our best to respond to those questions. This webinar is also going to be, has been recorded, and we will be posting it on the website so that you can listen to it again. There's been a lot of information here, and I appreciate that there's a lot to take in, and it's very fluid, and there's a lot of moving pieces. So some of this information may change as things evolve. So please reach out to us as Mass Dental if we can help you in any way. And I really want to thank Elizabeth. You've been terrific, and I really appreciate your time.
Of course, anytime, Ellen.
Thank you.